Hello, my name is David Siegel. Thanks for joining me. I'm a bankruptcy attorney in Chicago with offices in the Loop, Wheeling, Waukegan, Aurora, Joliet, Westchester, and South Chicago in the Beverly neighborhood. One of the questions that I get during the process very often is whether or not someone should reaffirm and what is a reaffirmation agreement. A reaffirmation agreement is basically an agreement to go back on the hook for a debt that was technically eliminated by the Chapter 7 filing. We see this most commonly with regard to an auto loan. Once you file a bankruptcy under Chapter 7, the obligation to repay the auto debt is technically eliminated. However, by signing an agreement stating that you want to be back on the hook and responsible for that debt going forward, you have in fact reaffirmed or re-obligated yourself towards that debt. This is important because whatever happens in the future with regard to that vehicle, you are on the hook. So if 6 months down the road you can't make that auto payment, now the vehicle could be repossessed, sold at auction, and a deficiency judgment or an amount can be come after you to pay the deficiency. That's the disadvantage of reaffirming a debt. However, the bankruptcy code mandates with an auto loan situation that you either reaffirm, redeem, or surrender. You can't just ride through and make voluntary payments. In that case, a creditor can repossess the vehicle even if you're current. With regard to real estate, your home, there is no mandate to reaffirm the debt. In fact, the bankruptcy code specifically does not have language stating that you have to reaffirm the debt. You can simply make voluntary payments on your mortgage, and the creditor is prohibited from beginning foreclosure proceedings provided you are up to date on your payments. So to reaffirm a debt, in essence, is to go back on the hook for that debt and put yourself in the obligation standpoint of having to make those payments going forward.